We should not sit here and because of politics, Oforiwaa-Atta made your family members have free school. Your nephews, your children, your aunties, your friends, your mosque members, your church members. But for Oforiwaa-Atta, they would have been home. Let us stop these things against either NDC or MPP. Let us maintain our reputations as a house. Let us believe in one fact that we are one people with a common destiny as a country. All these things we must stop. That is what I mean. Yesterday's politics we should forget, because we are destroying each other and we call ourselves honorable members. We all deserve that. But please, Mr. Speaker, what I'm trying to tell the House is that sometimes because of politics we say these things, we think we are joking, but those out there, they believe in what we say and they disrespect all of us. Let us protect each other. Let us keep the dignity of this house intact and portray to the people out there that yes, we have changed. Mr. Speaker, I am ending by telling each and everyone, especially my brothers and sisters from the other side, to repent. To repent. These behaviors must be stopped. We don't do that to ourselves. Look at the leader, we are all respectable members, but because of politics, I should call you thief, you are this, you are that, and when you go out there, you want people to respect us. I think this
after this fufu and pepper soup,
we are all respectable members, but because of politics, I should call you thief, you are this, you are that, and when you go out there, you want people to respect us. I think this should be the last time for all of us. Let us show love and constructive discussions. Constructive conflict. Conflict C type, not A type.
All members conclude.
Mr. Speaker, in conclusion, I would like to re-emphasize the point that thank you very much.
I proceed to give the floor to
Thank you, Mr. Speaker, for giving me the opportunity. Mr. Speaker, the Honorable Oforiwaa-Atta is not above the law. He is not above the law. And then when the special prosecutor, they read the statement today, he is talking about the cathedral. They mentioned cathedral issue. They mention SML issues. Those are the issues the special prosecutor is investigating. When they call upon Honorable Oforiwaa-Atta to avail himself to the authorities to do the needful, he sent lawyers, and the lawyers they want to represent him. Where is Oforiwaa-Atta? He's outside this country. We call upon our former finance minister to do the needful and come back to Ghana and do the needful. This is about public money. It's not personal money. He's not above the law. The security agencies went to the house lawfully. What we should be looking at is that we should inquire as a house whether they have search warrant to go to Honorable Oforiwaa-Atta's home. What we should be looking at is that we should inquire as a house whether they have search warrant to go to Honorable Oforiwaa-Atta's home. It's not about wearing white dresses. So nobody is above the law. When you hold public office, you need to be what? Accountable. The day of accountability have arrived. We were in this country. John Jinapo's home was raided. Former Attorney General's home was raided by the military people. Members were invaded in this chamber. At that time, we don't have the locus to say and condemn it. Today we have the moral temerity, the audacity to say that it is wrong. You have the moral ground to talk. You didn't know the day of reckoning will come today. Here we are. Now here, karma. This is what we call karma. Karma is real. Those days where even members of parliament are being chased. They can prevented. They can't even do the due duties. Here we are. So All that I want to say is that Ken Oforiwaa-Atta is not above the law. He should submit himself. He should stop running away. He's out of the country. Please, please, please call upon him to come back to the country. He shouldn't run behind excuse of medical condition and he will not come. He is fit for purpose, and then we are waiting cautiously, we are waiting patiently for Honorable Ken Oforiwaa-Atta to arrive in this country to submit himself to the authority for the needful to do. Why? What are you running away from? What are you running away from? Cathedral, 58 million Ghana cedis was sunk. Dollars, $28 million. $58 million. Which can build Kosimiti, can build a lot of road. It can build Kosimiti. Is it not true? OPK, is it not true? It can build hospitals. It can build markets. He can do a lot of roads. The agenda 111 business would have finished.
Honorable conclude.
And what are we talking about?
Honorable Gakwe, conclude.
What the SML? Is it not true? Is it not true? Yes. The biggest hole ever Ghana have actually constructed. So nobody is chasing former minister for me. He is supposed to submit himself. And he is not above the law. Mr. Speaker, on this juncture, he swore an oath to protect the public purse. And now the day of accountability is here. So he should just commit himself. Thank you very much for giving me an opportunity.
Now, leadership of the House.
Mr. Speaker, thank you for the opportunity to make my comments on this matter. Mr. Speaker, Honorable Ken Oforiwaa-Atta, a former Minister of Finance and a former presidential envoy, has contributed to nation building. This House, Mr. Speaker, had to wait because he indicated he was unwell and seeking for medical treatment outside. Mr. Speaker, in fact, when he even came, he was the only minister that his vetting took 2 days. And in between, this House indulged him to enable him take some break, to enable him proceed with his vetting. Eventually, he left government as a cabinet minister. And, Mr. Speaker, for the records, on the 2nd of January 2025, he wrote to the then Chief of Staff that he needed to travel to Mayo Clinic in Minnesota, USA, for some medical procedure. Mr. Speaker, after President Mahama had taken office, he again wrote to the current Chief of Staff in a letter dated the 22nd of January 2025, indicating that he would again be absent from Ghana for the same purpose. Mr. Speaker, in fact, in the said letter to the Chief of Staff, he attached a letter from the hospital that he was seeking treatment. Mr. Speaker, indeed, the OSP wrote to him on the 24th of January. In fact, this is the first letter that he received from the OSP. Mr. Speaker, in the said letter, Mr. Ken Oforiwaa-Atta instructed his lawyers to respond to let the OSP know that indeed he was out of the jurisdiction seeking medical treatment. Mr. Speaker, what happened yesterday by state security operatives must be condemned by all of us. Honorable John Jinapor has narrated his own ordeal, but the records of this House will confirm that when that happened, Right Honorable Speaker Okwe condemned that act. If indeed something had happened yesterday, it does not mean that we should continue today. Mr. Speaker, I have heard human rights activists, respected lawyers for that matter, quote Article 18 of the Constitution to say that that is not applicable in this case. Mr. Speaker, I beg to submit that that was a wrong appreciation of the law. Military men led by Mr. Richard Jakpa unlawfully entered the premises of Mr. Oforiwaa-Atta, searched his rooms.
Honorable Minority Leader, the unlawful entry is by your own determination.
Mr. Speaker, you know that by virtue of where we sit, we are able to do some background check before we come here. I wouldn't want to mention names, but Mr. Speaker, when inquiry was made, Mr. Speaker, when inquiry was made, it was our democracy is still young. Today it is Ken Oforiwaa-Atta, tomorrow it will be another person. Some of our colleagues should not forget that only yesterday it took the intervention of certain prominent members of our side to ensure that they were not mistreated. We will not mention names. They know. So these should be the voices of reason on this occasion. Some members worked in the night to ensure that people, members of the political class who are members of this House, were not mistreated. Mr. Speaker, let me remind colleagues, today, if you are praising the OSP, let's not forget that not too long ago, we had some of our members at the receiving end by the OSP. Don't let us also forget that even the president himself became a subject matter of OSP investigation, and he was not happy with certain words used by the OSP against him. So don't let us celebrate. Don't let us celebrate because today it is Ken Oforiwaa-Atta. Mr. Speaker, all manner of things are being said that Ken has done this, has done that, has done that. I listened to my colleague from Keta, and I listened to my respected colleague from Bogatanga Central, enumerating what to him amount to offenses. And they also argued again that the man has not been tried, therefore there cannot be any human rights abuse. Mr. Speaker, if you invade somebody's home and raid his home, Article 18 of the Constitution protect that person, except when you are doing so lawfully. On this occasion, there was no such law. There was no such law supporting their actions. So they shouldn't be here happy with it. These 4 years will soon come. No, Mr. Speaker.
Honorable member, I think the honorable member's order, that response was in respect of the allegation of breach of natural justice. And you and I are very much aware that natural justice is in two main ways: the Odi Atram pattern and Nemo Judas in Kansaswa. But actually not in respect of the Constitution. The statement states there was a breach of natural justice.
Mr. Speaker, the contention here is that the man's home was raided by state security operatives, rather unlawfully. And I dare contend that that conduct was unconstitutional. That is my respectful submission, Mr. Speaker. Mr. Speaker, I have done a lot of follow-ups on this matter, and I regret to say that we are not sending the right signal to our electorate. Mr. Speaker, the man has put the state on notice of his absence from the jurisdiction. He has made available his medical records coming from a respected medical facility. Mr. Speaker, today, I repeat, if our friends think that it is another person, so it is okay, and they are describing Ken Oforiwaa-Atta in all manner of forms, let me remind them that none can ever rule this country with perfection. The man, Mr. Speaker, at the risk of being repetitive, Honorable Stephen Amwa was clear in his language of submission that indeed the successful implementation of the free SHS was led by Ken Oforiwaa-Atta as a finance minister. He made sure that he rolled out all important policy of government. Mr. Speaker, if you have any issue, follow due process of law. It is not enough for national security to raid his home. It is not enough to carry armed military men to his residence to terrorize his children and by extension his neighbors. Mr. Speaker, we must, as a house, be united with one voice to condemn this act. Today is Ken Oforiwaa-Atta. Next will be other appointees. Mr. Speaker, we must not allow this. Mr. Speaker, only yesterday we saw the Attorney General applying to the court with an application we call noli prosequi in law, simply saying that he's discontinuing certain cases. That is within his right as an Attorney General. Mr. Speaker, what signal are we sending to the nation that, oh, if it is NDC and NDC is in power, it is right. If it is MPP and if it's MPP in power, it is right. Mr. Speaker, the political class of this country must rise above this. The political class of this country must rise above this. And I would conclude by saying that if indeed...
Honorable member, will you... No, I mean you are looking back. It is you I'm talking to. You are looking back. It is you I'm talking to. Will you listen to the leader in silence? Why? Leader, continue.
Mr. Speaker, Honorable Member for Keta talked about karma. And I agree with him. I've been reading a lot about karma. The wheels of karma indeed grind slowly, but with great surety. You have quoted it today. Enjoy it whilst it lasts. Mr. Speaker, today he says that we are reaping the fruits of a karmic effect of our actions. So it should be so. You have just come into government. You have a lot of projects you want to undertake. You will be going to PPA. Ministers will be taking decisions. Some will be good, some will be bad. You will roll out policies for Ghanaians to benefit. Some will pay, some will not pay. You would engage the business community. So bear in mind that this karma you have just referred to, 4 years from today, we may. You can even call it 50 years. 50 years, 60 years. So let us solve the problem now. Let us encourage state security agencies with a mandate to investigate and prosecute to follow the law. Let's encourage them to follow the law. Honorable Nitiwu, in his submission, was being very emotional because just a week ago, he had to invite the leaders to intervene. Some, and the clerk, some people calling themselves state security operatives chased him, his car, a former defense minister. And when they saw the car papers, they now realized that whatever the information they had was wrong. A colonel had to come, and when he questioned them that who sent you, they could not mention. So when we give certain wrong signals, some of those people at the lowest level take advantage to harass people, and even senior members who give order, when they realize that it is wrong, they are unable to even own up. Honorable Nitiwu, a former defense minister, suffered this just a week ago. It took the intervention of leadership and the clerk to parliament to sanitize the situation. Is that what we want? Is that what we want? Mr. Lord Comey, his house was raided. They searched his house, took away all his cars, and after 3 days, they said, we are sorry. They brought the cars back. Is that how we want to govern the country? Mr. Speaker, I shall conclude by urging my colleagues to support this call in bringing sanity in the country, so that nobody will take advantage to unleash any violence on anybody. I rest my case. Thank you.
Yes, majority leadership.
Mr. Speaker, before the statement was made, I had cautioned that this is a statement that definitely will generate commentary that will provoke debate in clear violation of our standing orders, and I caution that it is a statement that will attract comments that will go to perhaps damage the reputation of somebody who is not in this chamber. I cautioned, but my friends on the other side insisted and made a statement. Mr. Speaker, if you are a believer in the rule of law and you know the law, you know that if you claim that somebody has improperly searched your house or your property, you go to court. You go to court for the courts to declare that your property rights have been violated, that your dignity has been violated, and the courts are there to provide you that service of taking a decision as to whether or not indeed your rights have been violated. In court, the two sides will be there, and they will all be heard. But if you choose to use a political platform like this one, Parliament, to raise matters that, properly speaking, are the business of courts, you will receive political responses. And that is what I see happening here. Mr. Speaker, as for me, what I hear being said here is that there is a certain class called the political class, and that political class must take care of each other. And what I hear being said in this chamber
is that taking care of each other means that we should not hold each other accountable. Mr. Speaker, I have always contended that it will be the most dangerous thing that will happen to the democracy of this country if a certain group called the political class are allowed to conspire to protect each other. Because what will happen, Mr. Speaker,
Honourable members, order.
Mr. Speaker, I am saying what I hear. What I hear. There has been several referrals to a group called political class. Did you hear that or not? Several times there was a referral to a group known as a political class. And several times a call on members of the political class not to do this to each other. And what do we mean by let's not do this to each other? Let's not, when there is a change in government, try to hold each other accountable this way or that way. I take a position that, indeed, the reason why the voters go and vote for one political party as against the other is so that they will come and hold each other accountable. The day that we stop holding each other accountable, that will be the day the electorate will lose confidence in this democracy. And when they lose confidence in this democracy, that is the end of democracy in Ghana. So we must hold each other accountable. When we vote for a new party and the party come, they owe a duty to those who voted them to hold those who have been taken out accountable. As for how they do it, it should be a matter of following due process and the law. Let's talk about nolle prosequi. I heard somebody mention nolle prosequi. And withdrawal of prosecutions. Mr. Speaker, if the state of Ghana, if the Republic of Ghana prosecutes a citizen for 8 years and is unable to convict that citizen, then there's a problem. There is a problem. How can the state mount a prosecution for 8 good years with all the resources at the disposal of the state and yet not be able to convict that citizen? Or at least get a ruling on that citizen. Either you are guilty or you are not guilty. So when you are unable and you try somebody for 8 good years, and you cannot secure a conviction, then clearly there's something wrong with the case. And so if another Attorney General comes and is convinced that you don't even have a basis for the prosecution and enters a nolle prosequi, that is not a case of clearing people. You had 8 good years to secure a conviction, and 8 years you failed. Clearly there's something wrong, and that is what has manifested itself in a nolle prosequi. Mr. Speaker, let me say that I cautioned against making the statement because I didn't want us to go into a situation where we'll be making unfair comments about somebody who is not in the chamber to defend himself. Mr. Speaker, the facts are simple. That military officers, policemen, and national security personnel invaded, entered, searched the private property of the former Minister of Finance. Mr. Speaker, I will not run any commentary on that matter until I've conducted some investigations, ascertain what the facts are, and then I will come and appraise this House of exactly what happened. so that we can be properly informed. If there is anything that we should condemn about what has happened, we can collectively as a House condemn it. I caution you that don't involve commentary that will undermine the image of someone, because I will not be happy if it is done to me, and that is why I objected. And so I'm not going to join colleagues to comment on the statement, except to add that the Office of Special Prosecutor has been severally mentioned. This was an office that was established to investigate and prosecute alleged cases of corruption and abuse of office by public officers. They have indicated that in this instance, they are investigating the former finance minister for two stated matters that they are investigating, which is matters relating to SML. I'm sure you are all aware that it was a big issue in this country where it is alleged that there was some corruption scandal relating to revenue assurance contracts awarded by the Ministry of Finance and the GRA to SML. And then secondly, there's this big issue of the National Cathedral, which we all know the story of, that some monies were paid for work that is supposed to have been done there, and it is alleged that the work has not been done. So the Special Prosecutor is seized with the matter, is investigating the matter, and wants the former finance minister to appear before them for some investigation. They indicate that there are two other matters they are investigating, but they haven't indicated exactly what those two other matters are. So, Mr. Speaker, let's be cautious.
Thank you.
Not to make statements prejudicial to the work of the Special Prosecutor. And that was why I cautioned and advised that we shouldn't raise the matter.
Good evening, ladies and gentlemen of the media and my fellow citizens. Upon assumption of office as the Attorney General and Minister of Justice, I have taken certain decisions on prosecutions that were instituted by my predecessors. That is the Honorable Gloria Akufu and the Honorable Godfrey Yeboah Dame. Specifically, I decided to drop the criminal charges laid against certain government officials who served in the NDC government that left office in January 2017. My fellow citizens, I did so mindful of the fact that I am serving in a government that came to power on the back of promises of exacting accountability from everyone who has served or is serving in public office. I am here today to account to my fellow citizens for the decision that I have taken so far. As your Attorney General, I am keenly aware of the fact that the prosecutorial authority vested in me under Article 88 of the Constitution is discretionary in nature and is subject to the constitutional requirements set out in Article 296 of the Constitution. The import of these constitutional requirements is that in the exercise of my prosecutorial authority, I must not only act reasonably and fairly, but I must comply with all the requirements imposed upon me by law. I must also be candid with those whose life and liberty depend on my decisions. In addition, the Constitution requires that my decision to prosecute should not be capricious, biased, whether in resentment, prejudice, or personal dislike. Before taking any of the decisions I am about to explain, I consulted widely. One, I had several briefings from the Director of Public Prosecutions, that is the DPP, on each of the cases. Where I disagreed with her, I made my disagreement known to her with reasons. Two, I spoke to the defense lawyers in each of the cases, and again, where there were disagreements, as for instance in the banking cleanup cases, which I shall deal with shortly, I made my views known to the lawyers. 3, I spoke to some of the investigators involved in the cases at hand to get a sense of what they found during the investigation of the cases. And finally, I met with and discussed the banking sector cases with at least one of the receivers involved in those cases. I have scheduled a meeting with the second receiver, which is yet to take place. Ladies and gentlemen of the media, my fellow countrymen and women, the traditional view within the legal profession has always been that the Attorney General owes nobody an explanation for his decision to enter a nolle prosequi, which is Latin for there shall be no prosecution, or terminate a prosecution. But that view does not comport with the architecture of our Constitution, and I absolutely disagree with it. As ably articulated by Poorman JSC in his concurring opinion in Gregory Afoko versus Attorney General, which is suit number J1/8/2019, Supreme Court, dated 19 June 2019, at page 20, and I quote, "The decisions to prosecute and to terminate prosecution of suspected offenders is a matter of immense public interest. Furthermore, it affects the rights of the suspected offenders who may be compelled to suffer the indignation of prosecution when there is absolutely no point in mounting prosecution on the facts of the case. It is because of these considerations that the modern trend in democracies is for prosecutorial authorities to be open about the factors on which they take the decisions to initiate or terminate prosecutions." End of quote. Therefore, my decision to be open and transparent.
For about 2 years, the OSP point that up to now the OSP, they enjoy the services of soldiers and police to guide them on the advice of state security.
Mr. Speaker,
Majority Leader, continue.
the simple point I want to make is that all regimes at all times have used the military together with the police in certain operations. You agree that that is the case? So today, if you see the military and the police working together, you cannot suddenly create an impression that something that is unacceptable has happened. Because we have used them together. Indeed, Mr. Speaker, night security, just night security. When we should be deploying the police, we often deploy them with the soldiers. So let's not make it look like for the first time something that has never been heard of is happening in this country simply because a joint military and police team have visited the residence of the former finance minister.
Of the difference between the entry of a nolle prosequi and the withdrawal of charges. The power to enter a nolle prosequi is contained in Section 54 of the Criminal and Other Offences Procedure Act 1960. The Attorney General may enter a nolle prosequi at any stage of a criminal trial. The statute does not itself require the Attorney General to provide any reasons for his decision to enter a nolle prosequi in any proceedings. However, as I have made clear above, the constitutional principles in Article 296 impose an obligation on the Attorney General to be candid in the exercise of his discretionary power, and I cannot fathom how one can be candid without explaining one's actions. When a nolle prosequi is used by the Attorney General to terminate proceedings in a criminal trial, he reserves the right to bring fresh charges against the accused persons in the future. In contrast, the Attorney General may terminate criminal proceedings by withdrawing the charges against an accused person pursuant to Section 59 of the Criminal and Other Offences Procedure.
Politicians, investigation of politicians, we've all gone through all of that, and we are standing here, including my very good self. The OSP has investigated me, has taken me to, what they call it?
In other words, that accused cannot be brought back and tried on the same facts or for the same offenses. So in all the cases in which I have withdrawn the charges against the accused persons and in which the prosecution has closed its case, those accused persons are considered to have been acquitted and discharged. Ladies and gentlemen of the media and fellow citizens, my decision to terminate the criminal trial was animated in the main by three factors. The first was that for ethical and professional reasons, I could not in good conscience continue to prosecute some of the cases. The second was that for some of the cases, my own review and analysis of the charges showed clearly that the charges were defective, and some were filed against the promptings of plain common sense. The third was that in some of the cases, the evidence led so far that showed that there was a reasonable doubt as to the guilt of the accused persons, and no prosecutor should continue to pursue a case in the face of overwhelming doubt regarding the guilt of the accused person. Also, it is important to highlight the fact that in most of the cases in which I have terminated proceedings, the conduct of some of the individual judges left so much to be desired. I will deal with the issue of judicial conduct in my concluding remarks. Suffice it to say that it raises a specter of lack of fairness in criminal proceedings where a judge is seen to be overly hostile to the accused and unreservedly differential to the prosecution. Now to my first substantive reason for dropping charges in some of the cases. As I have noted above, for purely ethical and professional reasons, I could not in good conscience continue to exercise my prosecutorial authority under Article 88, Clause 3 in some of the cases. These cases were the Republic versus Oforiwaa-Atta and another, and the Republic versus Oforiwaa-Atta and another. This is because I was deeply involved as counsel in these two cases. In the case of Republic versus Oforiwaa-Atta, I was not counsel on record, but my junior partner, Godwin Kujo Tamaklo, also known as Eduji, was a counsel on record. As a team, we discussed our strategy in chambers, and I was involved in reviewing legal arguments and in some instances, authoring some of the arguments that we filed in court. I believed then, and still believe now, that the Honorable Oforiwaa-Atta was a victim of a political witch hunt, and that he had no case to answer in that trial. That position was vindicated by the erudite judgment of the Court of Appeal, which ruled that the trial court erred in calling upon the accused persons to mount their defense. When the then Attorney General, the Honorable Godfrey Yeboah-Dame, vowed to file an appeal and actually went ahead to do so, I took the view that it was done to save face and that there was no scintilla of merit to his appeal. Indeed, the appeal was, to say the least, grossly incompetent. My involvement in the case of Republic versus Oforiwaa-Atta and another is a matter of public record. At the initial stages of the trial, I was on record as counsel with the Venerable Tony Lita and my former boss, the Honorable Marietta Brew. It was our position as a team that the charges against the Honorable Oforiwaa-Atta were trumped-up charges and motivated purely by politics. I still stand by that view. Ethically, a prosecutor should and must have the courage of his convictions and must remain fearless to stand by those convictions even in the face of a severe storm of public criticism. Strident criticism should not be the reason why a self-respecting prosecutor must abandon his professional convictions in favor of political praise. So I am owning up, fellow citizens, to stand by the professional decision I took that in my current position as Attorney General and Minister of Justice, and for that matter the prosecutor in those cases, I was not going to suddenly recant my professional position and continue to prosecute the accused persons in those two cases. No new evidence has been presented to me upon assumption of office as Attorney General to cause me to abandon my professional convictions. As an aside, in any decent constitutional democracy, the disgraceful and unethical conduct of the former Attorney General, the Honorable Godfred Yeboah-Dame, in interfering with a key witness who also happened to be the second accused in the Ato Forson case, should have resulted automatically in a mistrial. But let us leave that for another day. Ladies and gentlemen of the media, the second reason why I dropped the charges in some of the cases, as I stated above, is that the charges were defective and upon careful scrutiny were filed against the promptings of plain common sense. In the case of Republic versus Collins Dauda and others, for instance, the first accused was charged with misapplying public funds to the tune of 200 million United States of American dollars. In laying the charges, the prosecution failed and or neglected to take account of the basic fact that it was part of that 200 million US dollars that was used to construct the houses at Sagleme. In other words, the value of that built environment is, in my considered opinion, a key determinant of how much of the total sum was allegedly misapplied by the Honorable Collins Dauda. Discounting the value of the built environment renders those charges, in my considered opinion, defective. The prosecution in this case also failed and or neglected to take account of payments that were made by other ministers who took office after the Honorable Collins Dauda. For instance, the Honorable Atta, as Minister of Works and Housing, approved a payment to the tune of 5 million United States of American dollars in 2017. That ought to have been considered in determining the value of state funds that the Honorable Collins Dauda had misapplied. But that wasn't done. And note, ladies and gentlemen of the media, that the Honorable Atta was never charged, even though the Honorable Collins Dauda was charged subsequent to the actions of the Honorable Atta. So I leave that to your own considered judgment as to why that happened. Now, in criminal law, an accused is entitled to know with precision the crime that he has committed and the burden that he must discharge in order to prove his innocence. This is basic criminal jurisprudence, and the charges in this case, and the other in terms of the cases affecting the other accused persons, fail to meet the standard of precision required to put an accused person on notice of his criminal liability. Ladies and gentlemen, the third reason why I dropped the charges in some of the cases was that the evidence adduced so far fell significantly short of what was required to convict the accused persons, and yet the state pressed on with the prosecutions. I consider that to be a total waste of state resources. As noted by Puamang JSC in Afoko and Attorney General, that is the case that I cited earlier, the prosecution may enter a nolle prosequi in situations where, upon review of the proceedings, the Attorney General detects fatal flaws in the case which may lead to the acquittal of an accused person. In other words, a nolle prosequi may be entered to avoid possible verdict against the prosecution. My review of some of the cases certainly revealed fatal flaws in the case of the prosecution. A few examples are in order. In two of the banking trials still ongoing, I took the decision to withdraw the charges against Mr. Johnson Pundit Asiama for the simple reason that in the course of my review of the cases, my attention was drawn to an internal memo prepared by the prosecutions division of our department for the attention of the former Attorney General, the Honorable Godfred Yeboah-Dame, which recommended that the charges against him be dropped. This is very significant. This is an internal memo prepared by professional prosecutors advising the Attorney General that the charges against our current Bank of Ghana, the governor of the Bank of Ghana, be dropped. Note that Mr. Johnson Pundit Asiama was charged with contravention of the Banking Act for granting a facility of 300 million cedis to Universal Merchant Bank and for causing financial loss to the state in the sum of 150 million Ghana cedis. The internal memo, which I just cited earlier, concluded as follows. This is very instructive. It says, a study of the facts of the case indicates that the initial facility of 300 million has been recovered, leaving 150 million outstanding. This office has confirmed from the Bank of Ghana, that is, the Attorney General's office has confirmed from the Bank of Ghana through Mr. Alexander Tarr, that is PW2, prosecution witness 2, that the interest from the outstanding amount is presently being serviced by UMB Bank. Mr. Tarr also indicated that UMB has an amount of 150 million locked up with CBG, that is Consolidated Bank Ghana. It is expected that when the said sum is released to UMB, the loan amount for which A3, that is Johnson Pundit Asiama, was charged with causing financial loss to the state will be repaid to the Bank of Ghana. This therefore may render the charges proffered against A3, that is Johnson Asiama, moot, leading to his discharge. So the professional opinion of the prosecution division was very, very clear that the charges against the current governor of the Bank of Ghana are unsustainable. In other words, factually, and then in terms of the evidence available, he could not be convicted of the offenses charged. Obviously, the former Attorney General failed to act on these recommendations which were made to him by the prosecution division. If he disagreed with the recommendations, I am unable to say, but I agree with them. Based upon these recommendations, I dropped the charges against Johnson Pundit Asiama in both the Unibank and UT Bank cases. In coming to this decision, I am fortified by the rule contained in Rule 40, Sub-Rule 2, Clause A of the Legal Profession, Professional Conduct and Etiquette Rules 2020, that is LI 2423, which provides that in a criminal case, a prosecutor shall refrain from prosecuting a charge that the prosecutor knows is not supported by the facts. But note that I have not yet dropped the charges against the remaining accused persons because I am currently in discussions with the receivers in order to understand the financial implications of any decision I may take in the future. Ladies and gentlemen of the media, my third reason for dropping the charges was that in some of the cases, the evidence led so far showed that there was reasonable doubt as to the guilt of the accused persons. And as stated earlier, the ethics of the legal profession mandate that a prosecutor should not continue to pursue a case in the face of overwhelming doubt regarding the guilt of the accused. In other words, where a charge is not supported by the facts and evidence, a prosecutor is ethically enjoined to drop the charges. I'll give you an example. In the case of Republic versus Stephen Opuni and another, the entire case was built around the fact that an untested liquid fertilizer, Litovit, was purchased by Cocoa Board, and further that the fertilizer was not efficacious. In the event, according to the case of the state, all sums of money spent by Cocoa Board to purchase this fertilizer caused financial loss to the state. Rather strangely, not a single farmer was called by the prosecution to prove this fact. On the contrary, officials at Cocoa Board who were invited by the investigators gave statements to the effect that Litovit fertilizer was one of the most effective fertilizers purchased by Cocoa Board, and that the farmers preferred Litovit fertilizer to the granular fertilizer. More importantly, in the course of the investigations, Cocoa Board took statements from two farmers. whilst one stated that he did not see any significant change on his farm, the second farmer stated that after using Litovit fertilizer, he saw a significant increase in yield, and that Litovit fertilizer is a very good fertilizer. Again, in the course of the trial, the defense tendered an official report from Cocoa Board which covered field visits by Cocoa Board officials. The report, which was tendered, was to the effect that Litovit fertilizer is a very good fertilizer and was the fertilizer of choice in areas in which Litovit fertilizer was supplied. This is clear evidence that, contrary to the case of the prosecution, the use of Litovit fertilizer rather increased the yield. The farmers who used Litovit fertilizer, including the then national best farmer, in their evidence testified that Litovit fertilizer increased, the use of Litovit fertilizer increased their yield, and that it was a good fertilizer. During the course of their investigations, the investigators had two reports from Ghana Standards Authority on Litovit fertilizer. The first report, which was later confirmed to have been done, and listen to this carefully, members of the press, to have been done at the Cosmetics Department of GSA, the department which does not have the mandate to test Litovit fertilizer, okay, indicated that the sample of Litovit fertilizer submitted for testing did not have any fertilizer ingredient in it. This finding was challenged by the accused persons and the investigators, together with representatives of Cocoa Board and the suppliers of Litovit fertilizer, took a second sample from the warehouse of Cocoa Board. This sample, which was again tested by the same Ghana Standards Authority, but this time by the proper department with the mandate to test fertilizers, concluded that the samples taken was fertilizer in the first place, and that the fertilizer was efficacious. Furthermore, it is interesting to note that in this case, the complainant, that is Dr. Edu Ampoma, who was the third prosecuting witness, PW3, lied under oath to implicate the accused persons, for which reason a perjury application was filed by Dr. Stephen Opuni against him. The then trial judge, Justice Hoyenuga, for reasons which are totally unacceptable, did not hear the application, but rather stated that hearing the application will prejudice the hearing of the main case. He therefore adjourned the application until the conclusion of the case. This is most unacceptable because in a criminal trial, it is important to hold the scale of justice evenly, and any doubt raised must inure to the benefit of the accused persons. Ladies and gentlemen of the media, my fellow countrymen and women, the judiciary in our country is independent under the Constitution. In the context of criminal justice, judges demonstrate their independence by remaining neutral and impartial arbiters in disputes between the state and individual citizens. The scales of justice must be held in a delicate balance between the obligation of the state to prosecute crime and the right of the accused to a fair trial. Conduct by judges that undermines the fair trial rights of citizens should be concerning to a self-respecting prosecutor. Without meaning to impugn the integrity of any of the judges who were involved in the cases in respect of which I have either entered a nolle prosequi or withdrawn the charges, I am deeply concerned not only about the conduct of some of the judges, but also concerned about the fact that the executive branch took certain actions that could be reasonably interpreted as inducements to convict the accused persons. An ethical prosecutor must endeavor to protect the innocent and convict the guilty, and one cannot do so if the judiciary is not impartial. When Justice Hoyenuga single-handedly expunged otherwise exculpatory evidence from the record in the Opuni case, and then proceeded to rule that the accused had a case to answer in his ruling on submission of no case, he was far from portraying a semblance of neutrality. Indeed, he directly undermined the fair trial rights of the accused persons. Again, when in accordance with law and practice, Justice Anoche Jima decided that he was going to hold a de novo trial, that is a new trial, in the same Opuni case after not the resignation, when Hohenuga went on retirement, the retirement of Hohenuga, he was instantly transferred to Kumasi. And the case was allocated to a new judge, who then proceeded to adopt the proceedings and continued the prosecution. Also, the decision by the executive branch of government to promote some judges who were sitting on some of the cases is very concerning. The perception, whether true or not, is that the promotion may be an inducement to convict the accused persons. Ladies and gentlemen of the media, fellow countrymen and women, in conclusion, I wish to make it abundantly clear that I did not take these decisions lightly. As I indicated above, I consulted widely and reviewed the files diligently before coming to a decision on each of the cases. You would note that in some cases, such as the SNIT case and the banking cases, I withdrew the charges against some of the accused persons, while others are still under consideration. I am keenly aware of the need to balance the public interest, in this case, against the interests and rights of the accused persons. Also, as Attorney General, I take absolute responsibility for all the decisions so far taken. I am not under any instructions or pressure to discontinue any case or to bring charges against anyone. Those who are in a haste to tag His Excellency the President of the Republic as a clearing agent should hasten slowly, because he is not responsible for prosecutions and has not directed me to drop any case. Moreover, with the exception of one charge of bribery in the Opuni matter, in respect of which, listen, no evidence was laid, none of the persons affected by my decision so far has looted state resources. There is a gulf of difference between the offense of causing financial loss to the state or misapplication of state funds and the offenses of bribery, corruption, or that of using public office for private gain. In the latter offenses, the individual charge can be accurately labeled as looters. In the former, it will be thoroughly unfair and actually defamatory to label the accused persons who have, as people who have looted state resources. So I thank you very much. These are the reasons for my decisions, and I will now take questions if there are any. Thank you.
We're still live on TV3. We've been bringing you live coverage of the press conference by the Attorney General, who has just finished speaking to the media primarily to give reasons why, upon resumption of office, he filed a number of nolle prosequis on cases that have been pending in the courts. One of it being the fact that he thought a number of them did not have the requisite evidence. So let's go back and listen to the questions being asked.
That's what we're seeing now, with you giving reasons for the decisions taken, is a standard that would continue in subsequent decisions of discontinuing cases, if you are going to discontinue any more cases from today. And then also, these persons who are affected by these cases that you have discontinued, have any of them sought compensation from the state because of what, according to you, they have been subjected to, which you say is unfair? And then also, from the reasons that you gave, especially with reference to the Atoforsin and the banking sector cleanup case, you referenced the unprofessional conduct of the former Attorney General. Are you minded or going to consider taking any action whatsoever against him if that's the position that you take, because of the description that you give to some of the decisions that he took? And maybe finally, you give very detailed reason for the decision to discontinue the case against Dr. Siama. With the UMB, clearly, as indicated, 300 million has been paid, 150 million outstanding, and there are already measures to have UMB, that money, unlocked with CBG. But in the UT Bank case that he was involved in as well, what reasons did you have in discontinuing that charge against him? Thank you.
We'll take a few more. Please don't follow Alfred's example. Stick to one as much as possible. Yes.
Senior, my name is Hansen Ajuman. I work with CTFM Channel 1 TV. On the first reason, which has to do with the ethics, and because you were lawyer for some of the accused persons, even though you did not represent them in court, I want to find out, would that be the posture going forward for all cases that your firm may have represented that the Attorney General's office is prosecuting? And because as a lawyer, you would definitely have to have faith in the case that your juniors will take before you allow them to do so, or yourself will do so, meaning that those cases you're going to discontinue seeing. And then for the second and third reasons, for some of the cases, people think that there are genuine reasons why the state should go against some people. For instance, for the Saglemi housing case, apart from the fact that the facts as the Attorney General's department made known that the houses were less than the number that was initially contracted for, and more money has actually been expended than what was agreed, the housing project itself has stalled, and Ghanaians will want somebody to take the fall for that. Should we take it that this is the end, or you're reviewing your books to see if you can get some better evidence and even get some other people to prosecute? Thank you.
Thank you. Take another one, and then we'll take a response. There's no hand raised.
Oh, okay. Yeah, thank you very much, Alfred, for that battery of questions. Yes, as I made clear in the statement that I read to you, I think that every Attorney General has a constitutional obligation to make clear his or her decisions when it comes to dropping charges, whether you are entering a nolle prosequi or you are actually withdrawing the charges. That is because I think that an Attorney General is not above the Constitution, and an Attorney General is subject to the requirements of Article 296. Now, for those of you who are interested, Article 296 is on the exercise of discretionary power. All right? And the power to prosecute is discretionary in nature. Okay? You have to make a decision to file the charges. You have to make a decision regarding the witnesses that you want to call. You have to make a decision, regarding whether or not to drop charges, as I've just done, and so on. So it's discretionary in nature, and it's subject to the provisions of Article 296, which says that the exercise of discretionary power cannot be arbitrary. All right, and then the exerciser of the power must be fair and candid. Right now, I don't know how anybody can be candid without explaining themselves. Okay, so for me, I think that this is a practice that has to continue. I may not in future be calling a press conference of this nature, but at least I may issue a press release, basically outlining the reasons why I have taken, I've taken a decision in respect of a prosecution or the other. Then your second question relating to compensation. I have not cited any formal request for compensation. As Attorney General, I'm not going to encourage it, and that if any request for compensation come, take it from me, I will fight it. Okay, take it from me, I'm going to fight it. Okay, so I'm not serving a warning to them not to bring requests for compensation, but if they do, I will fight it. Okay. Now, your third question said something about unprofessional conduct. I think I've. Yes. I mean, the former Attorney General. I think I want to reserve my views on that one, and to say that when we come to the bridge, we will cross it. So I'm reserving my comments on that one. Now, if you notice from the internal memo that I was referring to, there were two segments. One, the 300 million was in relation to Unibank. The 150 was actually in relation to UT. All right, and the memo covered both. And that is how come that I was comfortable dropping the charges, in both, because, I mean, I took the view, which was, shared by the professional prosecutors, that a charge of causing financial loss to the state will not be sustainable. The reason is simple. The charge of causing financial loss to the state is a legal concept, but it is drawn from accounting. All right. Now, if you say that financial loss has been caused, it means that through either the intentional or reckless or negligent actions of a public officer, all right, the state has incurred a loss that is irrecoverable. Now, I have always taken the view that where the so-called loss is recoverable, then it is notionally, and practically not a loss. So if the state can pursue and recover it, I'll be hesitant to take action against a person. But what has happened, look, let's go back to the history. The offense of causing financial loss to the state was first enacted under PNDC Law 78, I think. And that provision said anyone who does an act with intent to sabotage the economy of Ghana, all right, commits an offense. Okay, when we came into constitutional rule, because of the vague nature of the provision in PNDC Law 78, the lawmakers decided to redefine it, and that is how come that the offense of causing financial loss to the state, is on our statute books. All right. So for me, I think that unless we have a situation where the loss is irrecoverable, right, then you should not charge a person for causing financial loss. That is why the professional opinion of the prosecution division, is telling, because basically what it said was that, okay, the amounts in question for which the current governor of the Bank of Ghana was charged, okay, have been recovered. So if you've recovered the amount, then no loss has been caused to the state. So he should be discharged. Okay? It's as simple as that. Why the former Attorney General decided to proceed with the charges and to put the governor of the Bank of Ghana, Johnson Esiama, through the harrowing experience of attending court with potential consequences for his liberty, I am yet to find out. Okay, but I do think that ultimately, I haven't seen his reasons. He might have given some reasons to the prosecution division. I haven't seen them, but I think that my guess is as good as yours. It was probably animated more by politics than by law. Right?
Are you mandated to make that memo public for us all to see it, just in the spirit of transparency as you're doing now?
Well, I will think about it, because let me tell you something. There are public officers still serving in my department, all right, who are, who authored this memo. I have to think carefully about the consequences for them, in making the memo, public. All right, before I can do so, I have to be very considerate in making that decision. So I'm not ruling it out, but I have to be very considerate in doing so. Yeah. Yes. No, not GH1. Is it City? Channel 1. Yes. You asked about whether this is going to be my posture in all other cases in which my firm, is involved. The answer is no. The answer is no. That is because in some of the criminal cases, and I don't think my firm has taken any cases that are as high profile as this, right? But if they are defending a murderer, I don't see why I should step in and say I'm entering a nolle prosequi. Okay? Now, I will be very concerned if the state interest, okay, the state interest in the matter.
Edekom eda anachubiara enam se bosumi we eye bosumi a yede kye odonti no yasan aka ye ho abom eba be kye odo ama wona woni ho kwan awo ye mantemu onua brafo ye na eti ye nsafre obi biara se onfo odo emebe odo mu emaka ye ho sene emfi bibra besi atwemo no maye amana ye fe ye de serie ehye wona woni bi afono mu ma ye pese mofra dodo na ehu se ye ntu omagyeje mu enuti ye hwe enyankafo be se 500 ewo mofra place orphanage I would Jowolo on the 1st March 2025. And nam send your word of fonsem and or demanti. You are come away, Nessika Biara or Pase, would the boy no, obit me ascend the Ediafa, 0598 870 446 and now say, oh, near me be our pesa with the boy ya, obit me Ediaba Onia FM and Nimuhaya. And you may call our don't so a down Makuma so say, Omupesa Omuba Samo friends so no, a bit me Ababa Yemo free emwa, send ye beya, ye bit me the Syria, I show my funuma. Onya dofo braneba ka ye ho ni yentini yensa ema wona woni na eni echa sene beya ye de Syria ebe show mwanim Onya TV Onya FM eni Onya Foundation eni ya ka ye ho abom edi Onya boafa ye na dwumede eba be som Onya TV eni Onya FM ye se ye dwe wo pa